Okay, we are now streaming. You were on the record.
I just started.
Okay, Mr. Hotchkiss, I understand that in the stipulated order is going to be submitted in the Sullivan versus Overmeyer matter.
That's correct, Your Honor.
All right, and then, so the only other matter we have this morning is Braithwaite versus Overmeyer. Was scheduled for 8:30 this morning. You're the only one who's appeared. So I understand from the file that Mr. Overmeyer has some problems with the way the friend of the court calculated child support. Actually, I think he says the calculation is right, but the commencement date is wrong.
That is correct, Your Honor. So I reviewed his file, and I believe I found the error in which he's asserting. So it appears that he brought a motion before the court regarding child support in December of 2019. So just over a year ago. The court was inclined at that time to allow for child support to begin retroactively starting December 1st of 2019 at the time that he filed that then objection. There was a slew of objections that followed after the FOC had a subsequent order. Unfortunately, this was also the time period in which COVID began. And so there was a hearing date of, I believe, July 28th. And the court dismissed my client's objection at that time because he failed to appear. However, I believe it's the case that with Mr. Overmeyer, he moved from the Detroit area, I believe, to the Jackson area around Albion. And with COVID in the mail, I believe there's an issue with his mailing. He did not receive that notification properly. Not knowing what to do, my client then filed a subsequent motion regarding custody child support. And that's how I became involved in the case initially, Your Honor. So I was not privy to the prior child support objection my client had filed. I understand that the court's typical position is to have a reflective date of when a motion is filed. However, I believe that given the circumstance with COVID and my client's ongoing maintenance, that this child support should have a retroactive date further back. I believe the court should take that into consideration. The court has already included in its newest order, if its latest order, a retroactive date of November 1st. I would be asking the court to have a retroactive date of that December 1st, 2019 date, back to when my client had originally filed to have this child support issue resolved.
And during that interim, from when he filed his motion up to the present, has there been any significant change in parenting time or relative incomes of the parties?
Well, there has, Your Honor. I believe that COVID itself would be indicative of that, of the nature of that. My client was employed at a golf course. Of course, with COVID, that put the kibosh, you could say, on most of his employment, and that work is seasonal, Your Honor. My clients had significant issues with the unemployment distributions and has not been paid to date for 8 weeks. And there's a slew of times within this interim period in which he was not able to have employment, or with COVID had some difficulties in obtaining any sort of income. So I believe that at least during the span of COVID, so in the March, I think with February, March area, that was when it happened. I don't know if the court's aware or not, but there were golf courses that were closed during COVID, which made it so that my client was unable to collect any income during the time that the golf courses were closed. And then when they brought work back on, he was severely limited in the amount of time that he would be able to work. So I think that there has been a substantial change in circumstance due to financial issues with COVID-19. And again, seasonal work for my client. The parenting time, Your Honor, I do not believe has changed, just so the court's aware.
So if there's been no change in parenting time, but we have had a change in income since that order that started this ball rolling a year ago, my sense would be that we probably need two different child support orders. One reflecting the original effective date up until the next calculation that was based on his change in income. But the effective date of that one, I don't think should go all the way back to November or whatever it was, November 1st. I can't remember what you said.
Sure.
If indeed from that date until his income was impacted. But certainly I agree that if there was no adjustment effective when he originally, the date he originally filed his motion, that period at least should be corrected.
Sure.
And I would have to see the numbers to do that, but my inclination. Let me take a quick look at these orders. Maybe that will help, so you can be clear on what you put in the order of what I'm ruling today. I think it does need to be recalculated by the friend of the court, but I need to give them some specific direction.
Absolutely, Your Honor. I would note that from one perspective of parenting time, I know that my client raised concerns that during COVID, I believe that there was, him being from the Detroit area, he was not able to exercise his parenting time as frequently as he may have otherwise been able to, just because of the concern of COVID-19 and him being in one of the hot zones, or one of the breakout zones in Wayne County. And so that played a contributing role. Obviously, it's through no one's fault with COVID, but that was sort of an issue that arose at that time early on.
All right, let me did you submit a proposed order for today?
I did not, Your Honor. My client actually filed this motion on his own behalf. I was made aware that he had filed it, and so I had discussed the matter with him, and he wished for me to appear and articulate his position today.
All right. The reason I ask is I'm looking at a proposed child support order that indeed shows an effective date of 11/1/2020.
Yes.
So this must be the one he objected to.
Yeah, that's correct. If it's 11/1/2020, that would be the objection. Yes, that's correct.
All right. So hold on. So he doesn't quarrel with this calculation. He only quarrels with its effective date.
That's exactly correct, Your Honor. Exactly correct.
All right. Now, let me look back at the prior. Well, assuming, excuse me, the child support investigation report is accurate, the most recent calculation was based upon a motion he filed on August 5th of 2020.
And
So
that and
at a
that date does
minimum, pardon?
that date does sound correct, Your Honor. That would be correct. Yep.
So at a minimum, the current order should be given an effective date of August 5 of 2020. So let me see if there are any other modifications that are justified. All right, in the order that he the last order before that does have an effective date of 12/1/2019, pegs his child support at $393 a month. Let me see. So the first thing I'm seeing in this sequence, going back to 2019, end of the year, Mom had initially filed a motion for a request for a support review or a motion. Yeah, the file doesn't appear to be, I want to pull up the register of action because I want to make sure. I don't see any evidence of an objection being filed. That's what I'm struggling with.
Sure. I believe my client filed a motion regarding child support, Your Honor. I believe that's what it was that he filed. And it looks like the objection closest in time to the support motion in December of last year appears to me to be in May. It appears that there was objections that transpired in May of this year. And again, I believe that I can only assume that with COVID, there was various adjournments and whatnot. And then the court dismissed the objections in July for a failure to appear from my client. And again, I believe that was a mail issue. But that's my interpretation of the file, Your Honor, of course.
So I'm looking at the Register of Actions. So in January, we had referee findings in order after hearing, 21-day proposed order to be signed by the judge on 2/29. And then ultimately I signed it on March 2nd. It doesn't show that there was ever an objection filed or any kind of a hearing on an objection that your client failed to show up for.
I believe that there was, Your Honor. Let me look and see here.
The next entry after that USO was signed, which is consistent with what I was finding in the file, that's why I pulled up the register, wasn't until August of this year when another motion was filed. August 5th, it says.
Correct. I agree with the August date, Your Honor. I have no dispute there. I do believe it was the case that my client did object to the 21-day proposed order, however, and that those objections were subsequently dismissed due to a failure to appear on his part. But I am double checking that, Your Honor.
When I dismiss for failure to appear, there is an entry on JIS, the date that it was scheduled for hearing, and an indication whether, what happened that day. There's nothing. There was no hearing anywhere in that early part of the year. So I'm wondering if maybe your client's objection is that he didn't get the proposed order, so he wasn't able to file an objection. That's the only thing that makes sense in light of the Register of Action.
And that very well could be, Your Honor.
All right. Well, based on what I'm seeing, I am not inclined to grant any relief as to the order that was entered effective 12/1, but I will order that the newest support order be modified to include an effective date of August 5.
Thank you, Your Honor. That would be sufficient, I believe. I appreciate the court's time.
If you'll submit an order to that effect, I will sign it.
Excellent. Thank you, Your Honor. I appreciate your time today. And I'll get you the proposed order of the other matter early next week.
Well, again, Happy New Year and enjoy your construction projects.
Thank you, Your Honor. If I need any help, I'll give you a call.
Oh, I'm happy to help. Take care.
Thank you.
Well, it's showing Dennis in the waiting room. I wonder if that's for the 9:30 pretrial. Let me just check. You can take us off the record.